Hello, good afternoon. Um, Well, I'm Dr. Ramsha Khalik, and I'll be dealing with a company law paper from BCom fifth semester. So, all in all, we will be discussing around 15 units of company law. So, today we'll be starting Unit 1. In Unit 1, we'll discuss about the meaning definition of a company. We'll try to understand the exact meaning of what a company is before understanding what company law says. Yeah. Then we'll get to know about the characteristics of a company, like what a company looks like. Also, we'll understand the comparison between the company and partnership, or you can say the difference between company and partnership. Then we'll discuss about legislation and governing companies. Also, we'll discuss about the various kinds of companies, so as to understand the exactly what happens in company law. That will be easier when we get to know the various types and kinds of companies. Then there is one important concept in company law, a very basic one, which is known as corporate veil. We'll understand that. And the last topic from first unit is lifting of corporate veil and exceptions. So these are the topics which we'll be dealing in unit one. So let's start with unit one, the meaning and definition. Well, the concept of a company developed with the growth of trade, industry, and large-scale business operations. When business activities became complex and capital insensitive, there arose a need for an organization that could pool large resources, or they limit personal risk. Also, they ensure continuity. So the company form of organization fulfill these needs. Also, the term company has been originated from a Latin word which means two words, which means com, that means together, and panis, which means bread, which signifying a group of persons sharing a common purpose, right? Or in modern law, a company is not merely a group of persons, but an independent legal institution created by the statute. Now, if we talk about the statutory definition of a company, well, according to Section 2 of 20 of Companies Act 2013, a company means a company incorporated under this act or under any previous company law. So, this definition emphasizes incorporation as a foundation of a company's existence. Registration transforms an association of individuals into a legal person distinct from its members. So that is the statutory definition of company law. Now, talking about the judicial definition of company law, it says it was given by Justice Marshall. What he says that a company is an artificial being, invisible, intangible, and existing only in contemplation of law. So, thus, a company enjoy legal rights and obligations similar to a natural person, except those which are personal in nature. So that was the concept of company. Now we'll talk about the characteristics of a company. Well, very first characteristic is it is a separate legal personality. A company is a separate legal personality. So a company has an identity separate from its shareholders. This means that shareholders are not the owner of company property. Also, company debts are the personal debts of shareholders. Also, when we talk about a case law, there was a case of Salomon versus Salomon and Company Limited in 1897. There, the House of Lords held that a company is independent of its member even if one person holds almost all the shares. Now, that was the first characteristic. The second characteristic of a company is incorporation and registration. So, incorporation is compulsory. Only after registration does the company acquire legal personality, right to contract, right to own property. An unregistered company has no legal recognition. So, that is, in incorporation is very much compulsory. So, without incorporation, there is no legal recognition of a company. And only after registration, the company acquires, it has its own legal personality, it has right to contract, or has a right to own a property. Now, the next characteristic over here is perceptual succession. Well, by perceptual succession, we mean the life of a company is not affected by the death of the members, insolvency of shareholders, and transfer of shares. That is legal maxim. That is, members may come and go, but company goes on forever. That means perceptual succession. The company will go on whether any of the member of the company dies, or insolvency of shareholders happen, or any transfer of shares are there. So if any case, the company will go on forever, and if any members is coming and going, it will not affect on the succession of the company. So that is termed as perceptual succession. Next is limited liability, the fourth characteristics. So this is the greatest advantage of a company. Members are liable only up to the unpaid values of shares or the guaranteed amount. So this encourages investment by reducing the financial risk. So that is limited liability. That is the greatest advantage of a company, they're saying. So the members are, what are they, what is the limited liability over here? That the members are only liable to the unpaid value of shares or the guaranteed amount only. Okay, so this was limited liability. Next characteristics is transferability of shares. So shares in a public company are freely transferable, providing liquidity. So this feature encourages investment. It enables easy exit for shareholders, and that is transferability of shares. So it happens very smoothly. So the easily the members can, shareholders can have an easy exit. Also, this will encourage a lot of investment. So this one is very important characteristic, that is transferability of shares. Next is, it is a separate property and ownership. So a company can buy, sell, and hold a property. Also, it can use assets for its own business. So members have no direct claim on company assets. So that is the meaning of separate property and ownership. Okay. Uh, just a moment, please. Yeah. Now, the next characteristic over here is artificial legal person. Well, through though it has no physical body or mind, a company can enter into contracts. It can sue and be sued. So can be punished for legal violations. So it is an artificial legal person, that is, except personal offenses, They can enter into contracts, they can sued and they can be sued. Also, they can be punished for legal violations. So, though there is no physical body or mind, but these things can happen. That is artificial legal person, a company is. Now, next characteristic is common seal. That means symbolic authority. So the common seal act as a official signature of a company, though optional, it is very optional now. So historically, it authenticated company documents. That is common seal. Yeah. Next, last characteristics of a company is capacity to sue and be sued. We have already discussed this. That is, a company can initiate legal action and it can be sued independently of its members. So that is capacity of its members. So these were the characteristics of a company. Now we will discuss about a detailed comparison between a company and partnership. So in examination, if such kind of a question is coming, so it is advisable that you make a table, and on the left side, sorry, on the right side, you write down on the basis, like on what basis the comparison is being done. The first table, left side. In the middle, you make a table for company, and on the right side, you make a table for partnership. So like that, it will be better to write an answer like that when we are discussing the comparison between the company and partnership. Now, coming to the first left side, we on the basis, the first is the formation. So a company is registered, the company is being formed by registration, whereas a partnership is formed by agreement. So that is the difference between the two, the comparison. That is formation. The company is formed by registration, whereas the partnership is being formed by agreement. Now, the next comparison is legal entity. So, company is a separate legal entity, whereas partnership is not a separate legal entity like a company. That is a major difference between the two. Now, the third comparison is liability on the basis of liability. So the company has limited liability, whereas the partnership has unlimited liability. Clear? Now, next is succession. So the succession is perpetual, that is, just we have discussed that whether any member stays or goes, either is there is any insolvency or if anybody dies, the succession will go on. That is perceptual in nature. Whereas when we talk about partnership, it ends, or if the partnership ends if a member dies, or if there is insolvency, or if a member is leaving. So in that case, the partnership will ends. Okay, that is on the basis of succession. Now the next comparison is on a basis of transfer of interest. Well, the first is it is free. That is, in case of public company, the transfer of interest is free. Whereas in partnership, the transfer of interest is restricted. Okay. Now, now the next comparison is ownership. So, company owns assets, whereas partners jointly own. So whatever assets are there, that will be owned by the name of company. Whereas in partnership, the assets are being owned by jointly by the partners. That is the difference when we talk about the partnership. Yeah. Next is management. So the higher management in company is directors, whereas in partnership, the management is done by the partners. Now, the major comparison is legal compliances. So, and when we talk about company, the legal compliances are very strict, whereas in partnership, the legal compliances are quite simpler in nature. So, a company is more suitable, all in all, when we compare the company and partnership, we can say that a company is more suitable for large scale businesses, whereas partnership suits small enterprises. Right. So, that was one important answer from Unit 1, that is comparison between company and partnership. Now, moving on to the next topic. Yeah, the next topic is legislation governing companies. Well, in the according to Companies Act 2013, the Company Act 2013 introduced what are the things they have incorporated. The first one is stronger corporate governance norms. So the governance norms have become quite stronger. Then there was a mandatory corporate social responsibility for certain company. It has made uh, mandatory. Just a minute, please. Yeah. Yeah. So the first was stronger corporate governance norms, and the next one was about CSR. So they have made mandatory corporate social responsibilities for certain companies. Then they have provided a very important thing, that is protection for minority shareholders. So previously it was not there, but in Companies Act 2013 it has introduced about the protection of the minority shareholders, those who have smaller shares. Now, also the accountability of directors have been increased. So they have been held responsible for various things now. So these were the important thing which were introduced in Companies Act 2013. Now there are other related laws as well. So this is the SEBI Act is there. So basically, SEBI Act they regulate only listed companies. Then the next act is IBC 2016, which deals with insolvency solutions resolutions. Next one is Income Tax Act, which basically deal with corporate taxations, and FEMA is there. So FEMA deals with the foreign investment regulation. So these are the legal legislation governing companies. I hope that is clear. Okay. Okay. So the next topic we will deal is the kinds of companies. Well, a company is basically an artificial legal person created by law. So having a separate legal entity, perpetual succession, and a common seal under Companies Act 2013. So companies can be classified on various bases such as incorporation, liability, number of members, control, ownership, and purpose. Okay, so first of all, we will discuss the classification of companies on the basis of incorporation. Okay, the first one is the chartered companies. So these companies are incorporated by a special charter granted by the crown or sovereign authority. So they are common using the colonial period. So examples of chartered companies are East India Company or Bank of England. So what were the features of these chartered companies? So they were governed by a charter and they were rare in modern India. Now they do not exist, but previously, uh, like before independence, the existence of these companies were there in India about the chartered companies. Yeah. Next is statutory companies. So these companies are created by a special act of parliament or state legislature. Uh, then the examples of statutory companies is Life Insurance Corporation of India or Reserve Bank of India, State Bank of India. So they all are statutory companies which are created by a special act of parliament or state legislature. And what are the features of these companies? So they are governed by the statute creating them. Also, they are mainly formed for public utility services. Now, the next one under this category is registered companies. So these companies are incorporated under the Companies Act 2013 or earlier Companies Act. Examples are Tata Motors Limited, Infosys Limited, and they are most common form of companies. Basically, they are governed by memorandum and articles of association. So they are known as registered companies. So that was the first category, that is class on the basis of incorporation. So we have under this chartered companies, statutory companies, as well as registered companies. These three are there. Now, coming to the next category, we have classification on the basis of liability. So the first thing is company limited by shares. So the liability of members is limited to the amount unpaid on shares held by them. So let's take an example. Like if a shareholder holds share of rupees 10 each and has paid rupees 7. So liability is limited to rupees 3 per share only. So also most private and public companies fall under this category. Which category? The limited by shares. Okay. Now, next one is company limited by guarantee. So, members agree to pay a fixed amount in the event of winding up. Let's say clubs are there, then charitable institutions or educational societies are there. So they have a fixed amount in the event of winding up. So these companies may or may not have a share capital. So that is company limited by guarantee. Next one is unlimited company. So there is no limit on the liability of the members, and features are they are rarely formed. Also, the members' personal assets can be used to pay company debts. Now, the next category over here is classification on the basis of number of members. So, the first under this category we have private company. So a private company restrict the right to transfer shares and limit the numbers of members. Now the key feature is they have minimum members, that is 2, and maximum members, that is 200. Now they cannot invite public to subscribe to share, and they must use the word private limited. Let's take an example, ABC Private Limited. So that is a private company. Next, under this, we have public company. So a public company is one that is not a private company. And the key features of a public company is that the minimum members need to be 7 and there is no maximum limit of membership. So also they can invite public to subscribe to shares and must use the word limited. Just say, let's take example of Reliance Industries Limited. Now, the other one under this is OPC. OPC is one person company. So they are introduced by the Companies Act 2013. OPC allows a single individual to form a company. And talking about the features, only one member are there. It is a separate legal entity. And also it encourages entrepreneurship. Okay. So, an example of OPC could be we can write X Solution OPC Private Limited, like that, the name would be there. Now, the next category is on the basis of control. So, a company is a holding company if it controls another company, or control may be exercised through majority shareholders and also control over board of directors. So that is holding company. Next is subsidiary company. A company whose affairs are controlled by a holding company. Let's example could be Tata Motors Limited is a subsidiary of Tata Sons Private Limited. So that is a subsidiary company. Next is associate company. So a company in which another company has significant influence but not full control. Usually 20% shareholding is there. So that is termed as associate company. Okay. Now there is the next category on the basis of ownership. So the first under this is government company. So a company in which not less than 51% of paid up share capital is held by central or state government. Examples are ONGC, BHEL. They are governed by Companies Act. Also, they are subject to CAG audit. Then there are the second category, that is non-government company. So companies not owned or controlled by government are non-government companies. Now the next category is classification on the basis of listing. So the first thing over here is listed companies. So companies whose share are listed on recognized stock exchange, जैसे कि Infosys Limited. So they are subject to SEBI regulation. Also, greater transparency and disclosures are there. Then there is unlisted companies. So companies whose shares are not listed on stock exchange are termed as unlisted companies. Now, next category is classification on the basis of purpose. So the first under this is Section 8 company. So they are formed for charitable or non-profit purposes such as education, art, science, or social welfare. Also, the features are the profits cannot be distributed as dividends. Also, they enjoy certain tax exemptions. Examples could be various NGOs that are registered under Companies Act. That is Section 8 company. Next is producer company. So companies, they are formed by farmers, producers or agriculturists to improve their economic condition. जैसे कि FPO, that is Farmer Producer Organization, is a producer company. Now there are various other types of company as well. Uh, uh, the one is foreign company. So company incorporated outside India, but having a place of business in India is a foreign company. Then there is a dormant company. So a company formed for a future project or holding intellectual property and currently inactive. So that is a dormant company. Next, we have a small company. So a private company with limited paid up capital and turnover are prescribed under this act. Okay. So these are the various kind of companies. Okay. Now coming to corporate wheel we will discuss. So it is also known as doctrine of corporate wheel. First of all, let's understand the meaning of corporate wheel. Well, the corporate wheel refers to the legal distinction between a company and its members. So once a company is unincorporated, it becomes a separate legal entity which is independent of its shareholders, directors, and promoters. The wheel symbolically separates the identity of the company from identity of those who control it. So this principle was firmly established in the landmark case of Solomon versus Salman and Company Limited 1897, where the House of Lords held that a company is a distinct legal person, even if it is substantially owned by one individual. Okay. Now, legal basis, we'll discuss about the legal basis of corporate will. So the doctrine flows from the following principle. The first thing is separate legal entity, that is Section 9 of Companies Act 2013. Then it has a limited liability. So the member's liability is limited to unpaid shares or guaranteed amount and perceptual succession. So a company continues irrespective of change in membership. Thus, the corporate will protect members from personal liability for company's obligations. Now, talking about the importance of corporate will, so it encourages investment as well as entrepreneurship. It ensures limited liability. Then it facilitates risk taking. It promotes economic growth and it enables corporate continuity. So these are the importance of corporate will. Now there is important thing to understand under corporate wheel, that is lifting or piercing of the corporate wheel. So while the corporate wheel is fundamental, court may lift or pierce the wheel where the company form is abused. Lifting the wheel means ignoring the separate legal personality to identify the real persons behind the company. The Supreme Court of India has repeatedly held that the wheel may be lifted to prevent frauds, improper conduct, or evasion of law. Now, circumstances where corporate wheel is lifted, the very first circumstance is the prevention of fraud or improper conduct. So, when a company is used as a device to commit fraud, the court will lift the wheel. There was a case, Guilford Company Limited versus Horn in 1933. So, a former employee formed a company to avoid a non-compete clause. The court lifted the wheel and restrained the company. Now, the next is evasion of tax or statutory obligations. Well, if a company is formed to evade taxes or legal duties, the wheel can be lifted. There's a case of Commissioner of Income Tax versus Meenakshi Mill Limited in 1967, where the Supreme Court held that corporate personality may be disregarded to determine tax evasions. Next is protection of revenue. So courts lift the wheel where the company is a mere sham to avoid revenues law. There was a case of Sir Dinshaw Maningji Petit in 1927, So the SECs created companies to reduce tax liability. The court ignored the corporate structure and the wheel was lifted. Then there is a case of enemy character of a company. So during war, the court may lift the wheel to determine whether the company is controlled by enemy nations. Well, it happened in the case of Dalmir Company Limited versus Continental Tires and Rubber in 1961. Next is fraudulent or unlawful purpose. So if a company is formed for an illegal or fraudulent purpose, the wheel is lifted. The case of Delhi Development Authority versus Skipper Construction in 1996, the Supreme Court held that the corporate wheel can be lifted where the corporate personality is used to commit fraud. Then agency or trust relationship. So where a company acts merely as an agent or trustee of its member. The case of RG Films Limited, 1953. The court lifted the wheel to determine the real controller of the company. Then next is the group or holding subsidiary company. So court may treat a group of companies as a single economic entity in certain circumstances. There was a case of State of UP versus Renu Sagar Private Company in 1988. So where the Supreme Court lifted the wheel between the holding and subsidiary companies for determining electricity duty. Next situation is public interest or welfare. So, where required the interest of justice or public policy, the wheel is lifted. In the case of New Horizon Limited versus Union of India in 1995, the Supreme Court emphasizes that the wheel can be lifted to assess the true capability and experience of a company. Okay. Now there is a statutory provision for lifting the corporate wheels. So the Companies Act in 2013 expressly provide for lifting the wheel in certain cases. Section 7 of 7, incorporation by fraud. Then section 12 of 9, furnishing false information. Then section 34 and 35, misstatement in prospectus. Then section 339, fraudulent conduct of business. Section 447, punishment for frauds. Now we'll discuss about judicial approach in India. So Indian court follows a balanced approach, basically. So they respect the principle of separate legal entity, lift the wheel only in exceptional circumstances. Also, they ensure justice, equality, and good conscience. So the Supreme Court has consistently emphasizes that lifting the wheel is not the rule of an exception. Also, the doctrine of corporate will is the cornerstone of companies law, ensuring separate legal personality and limited liability. However, where the corporate firm is misused to defeat law, commit fraud, or harm public interest, court are empowered to pierce the wheel to uncover the real actors. Thus, the doctrine strikes a balance between corporate autonomy as well as legal accountability. Now, talking about a few exam tips for Unit 1. Always mention Salomon versus Salomon case or at least two Indian Supreme Court cases. Then, statutory provision under Companies Act 2013 is very important. Okay, so that was about the basic. Now, we will move on to Unit 2, that is incorporation. Just give me a minute, we'll start in a minute, Unit 2. Now we'll discuss about incorporation. So very first topic under incorporation is procedure for incorporation of a company. So incorporation is the legal process by which a company is brought into existence. Also, a company comes into existence only after it is registered under the Companies Act 2013. Incorporation gives the company a separate legal entity which is distinct from its members. Now we'll discuss about a step-by-step procedure for incorporation. Well, first is promotion of a company. So promotion is the first stage in the formation of a company. It involves conceiving the idea of a business, preparing the documents required, then arranging the capital, and lastly completing the legal formalities. That is promotion of a company. Then the next step is selection of a name. So the promoter must select a suitable name for the proposed company. The name should not be identical or similar to an existing company. Then it should not be undesirable or misleading. Also, the name should end with limited or private limited. Then the name must be approved by the registrar of companies, which is known as ROC. So that is the second step, selection of name. Now, coming to the next third step, which is preparation of documents. So the following documents must be prepared. The first one is MOA, that is Memorandum of Association, which basically defines the objectives and the scope of formation. Then we have AOA. AOA is Articles of Association, that is the internal rules and regulations. Okay. Then there is declaration by directors and subscribers. Also, address proof of registered office is required, and the identity and address proof of directors are also required for preparation of documents. Then the fourth step is filing of documents with registrar. So all required documents must be filed with the registrar of companies along with the prescribed fee. And the last step is the registration. So after verification, the the registrar registers the company and enters its name in the register of companies. Okay. So that is how the procedure of incorporation happens. Now, the next thing is certificate of incorporation under this. So the certificate of incorporation is an official document issued by the registrar of companies certifying that the company has been legally incorporated. Now, importance of certificate of incorporation are it is conclusive evidence of incorporation. Then it marks the birth of a company. It also grants legal existence to the company, and the company can now enter into contract and own property. So once the certificate is issued, the company becomes a legal person. Then the next thing is conclusiveness of certificate of incorporation. Well, the certificate of incorporation is conclusive evidence that all legal requirement of incorporation have been compiled with the company is validly formed. Even if there are defect or irregularities in registration, the certificate cannot be challenged. Now there is one important case law of Musa versus Ibrahim in 1887. The Privy Council held that once the certificate is issued, the existence of a company cannot be questioned on any ground. Thus, the certificate is final and binding on all person. Okay. Now, next we'll discuss about What is there? Promoter. We'll discuss about first the meaning and the role of promoter. First of all, the meaning of promoter. Well, a promoter is a person who conceives the idea of forming a company. He undertakes the preliminary steps for the incorporation, also brings the company into existence. Although the term promoter is not exhaustively defined under Companies Act 2013, it plays a crucial role in corporate formation and governance. Now, there is a statutory definition of Companies Act in 2013, the Section 2 of 69 of Companies Act 2013 defines a promoter as a person who has been named as such in a prospectus or annual return, or has control over the affair of the company directly or indirectly, whether as a shareholder, director, or otherwise, or on whose advice, direction, or instructions the board of director is accustomed to act, excluding professionals acting in their professional capacity. Now, who can be a promoter? Well, a promoter may be an individual, it can be a company, or it can be an association of persons. Professionals like chartered accountants, lawyer, or consultant are not considered promoters when acting purely in professional capacity. Now, next thing under promoter is legal position of a promoter. Well, the promoter occupies a important position in relation of to the company. Though not an agent or trustee in the strict sense, a promoter must act in good faith and in the best interest of a company. So there was a case of Erlanger versus New Sombre Phosphate Company, 1878. The House of Lords held that promoter stands in a fiduciary relationship with company and must make full disclosure of profits. Now talking about the roles and functions of promoter. Well, the role of a promoter can be divided into three major stages. The first is the preliminary or conceptual stage. Well, at this stage, the promoter conceives the business idea. It conduct feasibility studies. They identify business opportunity, decide the nature, name, and objective of a company, and also determine capital requirement. Then the next stage is the incorporation stage. So during incorporation, the promoter select the type of a company. It could be public, private, OPC, etc. Then prepares the MOA, that is Memorandum of Association, and Articles of Association. Then they appoint first directors, arrange for the registered office, files incorporation documents with the registrar of companies, then makes pre-incorporation contracts.
Okay, the next is capital raising and commencement stage. So after incorporation, the promoter raises a share capital, they arranges loan and financial resources, they issue prospectus, that is in case of public company. Then they enters into preliminary contract and they also ensure the compliance of commencement of business. Now we'll talk about few duties of promoters. Well, the first one is duty to disclose secret profits. So promoter must disclose any personal profit made during promotion. That is in the case of Gluckstein and Barnes in 1900. The secret profits must be returned to the company it was given. Then duty to of full disclosure. So all material fact related to transaction must be disclosed to the company, also to the independent board of directors, and also to the shareholders. Now, duty to avoid conflict of interest. So, promoter must not place themselves in the position where their personal interest conflict with the company's interest. So, duty of good faith, the next one, that is, promoter must act honestly and in the best interest of the company. Now, talking about the rights of a promoter. So, they have a right to be remunerated if agreed. Second is right to be indemnified for expenses incurred, right to recover legitimate production expenses, and the last right is to enforce pre-incorporation contacts, that is subject to adoption. Now talking about few liabilities of a promoter. The first is the civil liability, that is misstatement in prospectus section 34, 35. Fraud or concealment of fact is also there. Then second liability is criminal liability. The fraud under section 447. Also punishment includes fine and imprisonment. Then there is liability for breach of fiduciary duty. So refund of secret profits, also compensation for loss suffered by companies. Also, the importance of promoter in corporate governance when we say so, they shape the vision and values of a company. They also influence initial governance and structure, and they are responsible for ethical foundation of business, key stakeholder in shareholding as well as control. Then a promoter plays a very important, a pivotal role in the birth and the early life of a company. While enjoying certain rights, promoters are bound by strict fiduciary duties to ensure transparency, fairness, and integrity. The Companies Act of 2013 and judiciary precedents ensure that promoters remain accountable, thereby strengthening corporate governance and investor confidence. Okay, so that was about Unit 2 incorporation and all about what is the procedure of incorporation, certificate of incorporation, conclusiveness of certificate, promoter and meaning and role, then right and responsibilities of promoter, and pre-incorporation contracts. So when you are writing an answer from unit 2, a long answer is coming. So what are the major important things you need to remember and do not miss while studying is section 269. Then the fiduciary nature is very important. You need to understand the meaning and what are the features of that. And also, English cases are very important in incorporation, this unit. So, I have discussed about Erlanger case and Gluckstein case. So these two cases are important. So they need to be mentioned. First, read these cases and do mention these cases while writing the answer. So that was about unit 2. So I believe that is all for today because if we start also, we won't be able to finish out the next unit properly. So that's all for today. I'm dropping my email address in the chat box, which is visible here. For any queries or doubts, you can you feel free to put me an email. I'll be happy to help you. Yeah, it's here. So it's there on the screen. So you can anytime put me an email regarding any doubts, any notes. I'll be happy to help. So that's all for today.